time should we start?
Okay, yep. All right, so back to paragraph 18. I'm going to try to be mindful of the time and move as expeditiously as possible. Paragraph 18 is called a redemption of owner and waiver of redemption. The summary here is that after the landlord declares a default and the tenant is out of the premises either by voluntarily vacating or is evicted through legal process and a warrant of eviction, then the landlord has some residual leftover claims against the tenant for things like rent due, additional rent due for the remainder of the lease term that was unused as it accrues. This is less any rent that the landlord receives from a subsequent tenant that it rents out to. So it's called the sorry. Do you want to make changes to the device? No, it's still fine. So this is called the deficiency rent, the amount that's the difference between what's reserved in your client's lease with the landlord and whatever subsequent lease the landlord gets with the subsequent tenant. Whatever difference in rent there is, your client may be on the hook for that differential there. And there's other costs that are involved in re-renting the premises, like broker costs and attorney fees for review of documents that may be attributable to your client under this lease provision. This is a particularly problematic provision that I've long been thinking about. I think that it's ripe for some policy attention and maybe some work here on that front, because this is essentially a no defense situation. A commercial landlord has absolutely no duty to mitigate its damages after a tenant defaults. So a tenant defaults and either vacates or is evicted from the premises with 4 years to go on its lease, for example. The landlord can sit there with an absolutely vacant property, not put any other tenant in there or make any other efforts to put any other tenant in there, and continue to collect the rent from the evicted or vacated tenant for the remaining 4 years of the lease term. There's essentially no defense here, and I've done these proceedings where the landlord feels that the tenant either hasn't dissolved or there's a personal guarantor who's still on the hook with deep enough pockets. You can go after them, and there's essentially no defense here based upon how the lease provision is drafted and the case law that says that the landlord has no duty to mitigate its damages. It's essentially just a calculus. The court is just figuring out how much rent is actually due and what the damages to the landlord are. So be aware of that. Counsel the tenant on this issue, and know that it is kind of adding to the warehousing phenomenon that we're seeing in commercial spaces throughout the city. Right, and at the bottom, I quoted from a seminal case from the Court of Appeals that explains this lack of a duty to mitigate on the part of the landlord. The fees and expenses provisions are in paragraph 19, and any attendant provisions in the rider. Be sure that there will be attendant provisions in the rider, because this is where we talk about attorney's fees. The summary here is that to the extent there's any expenditure made by the landlord as a result of the tenant defaulting under the lease, including to cure the default, then it's payable by the tenant as additional rent. From the lease, the form lease includes reasonable attorney's fees that are incurred in connection with any legal action regarding the tenant's defaults where the landlord is the prevailing party. So if you have a summary proceeding where the tenant defaults and you end up in court, the landlord gets a warrant of eviction. They could also get, that means that the landlord won, and they'll also get all of their attorney's fees in a money judgment as against the tenant, either there in the summary proceeding, or it'll be severed for the landlord to be able to pursue with other monetary damages in a separate plenary action in the Supreme Court. And we'll talk about that a little bit more next week in the litigation section. In this provision, this is where we kind of talked a little bit about trying to even the playing field. I imagine you're going to see, we're all going to see a lot of unevenness here on the first draft from the landlord. The landlord's going to want to be very uneven in what the landlord can recover as opposed to the tenant. And here I want to try to obtain a reciprocal attorney's fees provision that will allow both, either party, the landlord or the tenant, to recover reasonable attorney's fees in the event that that party is the prevailing party in a legal action. that involves the lease or lease obligations. And so if the tenant would be entitled to its reasonable attorney's fees from a successful defense as against an action by the landlord, then the landlord would be discouraged from commencing frivolous actions and frivolous proceedings against the tenant. This is something that has been notoriously difficult to negotiate. This is something I'm hoping we can make a little bit of headway on, especially as more and more commercial tenants are going to be represented in the negotiation and lease drafting stage. All right. Paragraph. Yeah.
So for prevailing party, that means you actually have to get past the settlement. Most of the stuff's going to be settled at some point, correct? Rather than having necessarily an obvious prevailing party.
And that calculus is going to become a part of the stipulation. In whatever stipulation of settlement where you have a fees and expenses provision, it's always going to be in there that parties carry their own expenses, or the tenant or landlord will agree to take a portion of the other party's expenses.
And I guess from your experience, does the tenant ever get anything out of that? I mean, even if they just have the lawyer, the landlord's lawyer sends the rent demand usually rather than coming from the landlord, and then all of a sudden it's like, okay, well that took me an hour, so now we'll need $200 for that.
Yeah.
So do they sometimes waive those? What's the typical way that the landlord will handle that?
Well, if you settle by stip, then technically you don't have a prevailing party. Prevailing party in this context generally refers to either the proceeding being dismissed on procedural or substantive grounds, or on the other hand, the landlord actually getting a judgment of possession and a warrant of eviction. Those are the end goals that make a prevailing party. I don't believe when you settle by stipulation of settlement that it's usually dealt with in the stipulation of settlement. And if it isn't, then and the landlord later comes back and says, "Oh, I was a prevailing party because you agreed in this stip that you were that you were in default." I don't see a court looking on that as an admission of fault or an admission of who the prevailing party is necessarily. There may be some case law on this, but I get the impression that if you settle and it's not already in the stip, 9 times out of 10 it'll be in the stip who carries the costs. Is that your understanding too, Shanila?
If the tenant is required to seek counsel, then usually it's agreed that each party will bear their own costs within a settlement step.
Yeah.
It's usually part of the settlement or if you're going to trial.
Right. And if the landlord comes back after a stip and demands its attorney's fees, then there's plenty of defenses there, including waiver, because it should have been in the stip.
What if you settle before you get to a stipulated settlement? So they just are. The tenant has just been not paying on time, and so then, or it went several weeks, and they serve a rent demand. But then the lawyer, their landlord's attorney does it, and they charge for that.
Mm-hmm.
Do they have, then you don't have it stipulated. So what if we can negotiate and say, really, this took like 5 minutes of someone's time to do. You should be waiving the attorney's.
Right. Everything should be negotiable, but I would start with the language of the lease and see whether it actually says for a legal proceeding or simply for a default of the lease. Because if it's just for a default of the lease, then the tenant is contractually on the hook for those expenses of the attorney. If it says as a result of a legal proceeding, well, you didn't get to a legal proceeding there in that case because you settled before they filed and served a notice of petition. And so there you have some more, right? There you have some more leverage.
Sometimes the way I like to address that, and it gets back to that, it's still ambiguous language that allows people to dispute what we mean by it, but I like to add reasonable and documented, is that at least that provides room for me to now argue with you about what's reasonable. And if you hired a high-powered attorney to do a standard, notice to the client, we can argue one to the documentation and our fees are outrageous. Well, I can argue about reasonableness, and of course the landlord can argue that, but I sometimes find that provides a little leverage there because it's open to interpretation.
Great. Paragraph 20 talks about representations by the owner, or rather that the owner does not make any representations. This is the as-is provision. The landlord wants as broad an as-is provision as possible for the premises. with an acknowledgement by the tenant that the space and its condition have been inspected and are satisfactory for the tenant, and that the tenant, takes it for that it's satisfactory for its purposes to run its business out of the premises. The considerations here that you and your client should be making. I would counsel the tenant to thoroughly inspect the premises if possible, as well as to have an architect or contractor or other professional inspect with them to the extent that they're actually going to be doing any kind of build out in the premises in order to get their business running, and to have that professional advise them on the feasibility of the tenant's alterations that they want and the renovations, and to price all of that out before any significant lease negotiations occur. Because the space it may look, absolutely perfect to you, maybe absolutely in the perfect place, but you may have an inspector or an architect or somebody come in and tell you that, there's all kinds of corrections and renovations that need to be done that weren't intended, and just put it completely out of your price range. I would seek a representation by the landlord that all of the mechanicals, all of the HVAC, the heating, the cooling, the plumbing, the electrical systems, the elevator, all of those systems that are serving the lease premises and the entire building and any common areas, that they're all functional, and that the premises is also in compliance at the time of the lease signing with all laws, rules, and regulations. So put a little bit of that onus back on the landlord, because it is, after all, their property, and they should be offering you a good and legal property for you to be able to run your business out of. I would also review the public records for all open DOB, ECB, FDNY violations, do a complete violation search for the premises and see where the violations are, and if they touch actually the specific lease premises. If there are any, you should put a representation in there that it's the landlord's obligation to cure them. Make sure that the tenant doesn't take any liability with respect to fines, and put in a deadline for the landlord to cure or to diligently pursue cure. And I put in a few links here to some websites where you can do that investigation. If the tenant is going to need any governmental permitting in order to build out or to operate its business, in this provision or in conjunction with this provision, I would seek a representation that from the landlord that the space is permit ready, and to try to key the rent commencement date provision to the procurement of the necessary permits. You may get some pushback here because the landlord may say, I don't want to delay rent based upon administrative or bureaucratic delays of the Department of Health or some other public agency that he has no control over. So just know that this may be ripe for negotiation, but there's another actor here that's involved that may dilute your ability to get a really good provision.
Also, that permit ready, and that also the landlord will reasonably cooperate with the tenant in filing any necessary applications at DOB, because often they have to sign the application as owner, even if the tenant and its GC is doing the actual build out.
You could also include a provision there.
Definitely blown up in a lot of people's spaces where what they want to do is hypothetically legal and permissible, but there's just so many other structural issues with a larger building that DOB is like, you're not doing stuff in this envelope if you don't deal with the rest of the safety concerns. And the landlord will be like, well, I'm not fixing my roof, or I'm not repairing the boiler, that's not what I'm signing up for. So that's, I think, your note about going through this with a professional and checking DOB and all that is really important diligence.
Right. To the extent it's monetarily available to the tenant. And then one way of addressing that issue, Jesse, I think, is to include a provision that says that in certain circumstances the tenant can act as attorney in fact in signing some of these applications for the landlord. There's going to be a lot of pushback there, and there'll be a lot of negotiation from the landlord about exactly when that case will arise. But I have seen provisions where there's a procedure set up where the tenant provides a sample application to the landlord for approval and signature, and if the landlord doesn't object or otherwise reply within X number of days, then that automatically deems the tenant attorney in fact and gives them the authority to sign on their behalf under the contract and submit it to the DOB. or other agencies. So that there's potential for something like that to cut that off. Is there another question?
Yeah, so, would you include the provision about changes of occupancy here as well? Which would look like,
In what context?
just for something that for, if there needs to be a bidding modification of the certificate of occupancy to permit the tenants use of the space, that, how would want to do it or something?
For a change in use?
Yeah, so, yes, so that's just like on the list of many things the landlord will want to do and.
Right.
Do it
Right.
at the beginning, I think.
I mean, at the very least, you want the landlord to agree that this is the current certificate of occupancy. If you have any concerns about what is or isn't the effective certificate of occupancy, you could print it out, attach it as an exhibit, and say that the landlord represents and warrants that this is the effective certificate of occupancy, allowing setting forth the legal use for the premises as of the date of the lease agreement. As far as negotiating whose obligation it is to get a non-conforming use, we talked a little bit about that in the other provisions. That's going to be, it's going to be a negotiation tactic you'll have to do in conjunction with, with a lot of these other provisions. You may end up using a lot of negotiating capital on a big issue like that, because that's a big undertaking, and of course it involves a third-party governmental entity here, which is unpredictable. So even if the landlord is completely on board, the zoning authority or the DOB or whoever's in charge of it may not be, and you have to consider that as well. So the end of term is paragraph 21, talks generally about the tenant's requirements to return the possession of the premises to the landlord in vacant, quote, broom clean condition, and it reserves liability against the tenant for consequential damages for the tenant's failure to comply with this provision and for holding over beyond the expiration of the lease term. Broom clean condition is a term of art generally used both in residential and commercial leases. It is what you think it means. It just, it doesn't have to be spotless, but it has to be generally, broomed, clean and vacant. Holdover rent is a term that is defined as an agreed upon sum that's due from the tenant to the landlord for any period of time that the tenant remains in possession of the premises after the expiration of the lease term. And it's commonly, it's pretty punitive. It's commonly set at least twice the last current monthly rent amount at the time that the lease expired, because it's an inducement for the tenant to vacate the space in a timely manner. It does not serve to extend the lease term, and the landlord's acceptance of holdover rent doesn't create a new tenancy. The tenant is simply month to month at the new rate after the lease expires. The considerations for the end of term provisions that I would make here are to ensure that the tenant is permitted to remove all of its personal property, all of its trade fixtures in a timely manner, that it has enough time to do so, and that the tenant is not obligated to remove or to restore the premises to otherwise beyond normal wear and tear. Think about if the tenant is in there for 10 or 15 years, the space may look a little bit different than the day that it took it. The tenant shouldn't be required to bring it all the way back up to new or like new condition. And I would be aware of onerous abandonment language. I've dealt with this in numerous litigations on both ends, for the landlord and for the tenant, because of very vague abandonment of property language. And you should be aware of any language that automatically deems any of the tenant's property abandoned after the vacator or after execution of a warrant of eviction. That's very onerous. Sometimes the tenant is, if you can imagine, at the end of the lease term, or where there's active summary proceeding litigation going on and a marshal of eviction, and a lot of times the tenant is not in his or her right mind. There's a lot going on. It's a very stressful time, and you don't want the tenant to have deemed abandoned all of their property simply by the effect of a marshal coming in and executing a warrant of eviction. And make sure that that's not automatic, and that the tenant has enough time to be able to collect all of their belongings at the end of the term, no matter how the term ends. The quiet enjoyment provision, you probably remember that from property or from contracts. It is what it is. It just says it's a boilerplate provision that allows the tenant quiet enjoyment of the premises, so long as the tenant continues to observe its obligations, monetary and non-monetary, under the lease. It should be able to enjoy the premises for its purposes under the lease. Now we have this in conjunction with the commercial tenant harassment law, which we'll hear a little bit later about from Mia, that gives explicit remedies for certain conduct by the landlord. I kind of put it in here because I think this is probably a good spot to talk about that later on. Failure to give possession, 23. This comes into effect in the beginning of the lease or before the tenant takes possession of the premises, in the event where the landlord either isn't ready to give possession because it's not built out, or there's a prior tenant in there that just is still in possession and isn't leaving for whatever reason. You have a holdover tenant, or potentially the landlord hasn't gotten a certificate of occupancy or has incomplete construction, and the tenant can't take possession on the scheduled date in the lease. The considerations here should be to ensure that any rent is abated and that the rent commencement date doesn't occur until after the space is actually available for the tenant to take possession. I would try to also obtain an outside deadline for the landlord to deliver the space, beyond which the tenant is granted additional free rent, and make this, you can make this as an inducement, just like the holdover rent. You can do it, 2 free rent days for every additional day the premises is unavailable after the deadline. I've seen that before. Or you can try to include a termination right. If 6 months after the date set forth in the lease, the landlord is still not ready to give the premises over, then maybe the tenant has a unilateral right to terminate the lease and move on without any expenses, of course. You should ensure that the tenant is not obligated or liable under the lease until such time as it takes possession. But note that some of the other provisions are going to come into play here. For example, insurance. It should maybe potentially include in this provision that the tenant isn't required to provide insurance coverage unless and until it actually takes possession of the space, and that could be a good cost saver for the tenant. Okay, waivers. In paragraph 25, here's a boilerplate provision where the parties waive trial by jury. It's a standard waiver provision for any dispute that arises out of the lease, and it also buried in there includes a waiver that restricts the tenant from interposing any counterclaim in an action or a summary proceeding that's instituted by the landlord for possession of the premises. And so if the landlord brings either a non-payment or a summary or a holdover summary proceeding, this provision, if unaltered, is going to restrict the tenant from interposing an answer with any kind of counterclaim. The tenant will be required to bring its own plenary action in Supreme Court against the landlord at its own expense, rather than kind of including it and piggybacking on the landlord's action. The landlord's position here, in including this provision, they want to ensure that they have a streamlined pathway for regaining possession of the premises after there's a default. And counterclaims are perceived to lengthen or complicate these lawsuits or these summary proceedings. However, on the other hand, a tenant's ability to counterclaim in the landlord's suit could be a strong deterrent from the landlord for engaging in frivolous litigation. So to the extent this is a boilerplate provision, here's another kind of focal spot that I'd like to see some pushback on, because I don't find this to be effective. I don't find this to be fair in the administration of justice, personally. For example, the tenant would be unable to counterclaim for a set-off of money that's owed to it under the lease in a summary proceeding, but it could claim the set-off as a defense. So if the landlord is going after the tenant for unpaid rent, and in a summary proceeding, the tenant has a set-off claim saying, hey, there's an abatement provision, or I can set off X amount of these dollars that you're claiming because of this other provision over here in which you actually owe me money, landlord. I can't actually, as the tenant, counterclaim for that money. I can't actually get a judgment for that. in the summary proceeding, but I could still use it as a defense and say, no, I don't actually, you have no merit in this non-payment proceeding because we actually have a set-off. And so you should dismiss it on those grounds. So even with the boilerplate language, you could still use a counterclaim, the facts of a counterclaim as a defense.
We should kind of try to track as the project goes on when we kind of get landlords to agree to some of these more contentious provisions so that we can kind of build amongst us the ability to say, you know, we have 10 landlords who've agreed to this, so like it's not true that it's not standard. Like, you know, we can kind of collectively begin to kind of have that, even if it's like I haven't personally done 5 leases, if we're able to say like our group has had 10 attorneys who agreed to this strike through, you know, I think it may not be like a compelling argument, but it might help build momentum in negotiation.
I think it could be compelling because they're going to come back and say, I've never heard of this before.
Right.
And I say, well.
And we could say no.
Yeah.
You know, 5 other small businesses, you know, in this area or this type of lease or whatever.
Absolutely.
Or I think if you can at least say you've done one, or just argue that it's not reasonable. I mean, I think oftentimes we forget how strong an argument it is to say this should be mutual. You have this right to do this. If I sue you, you can counterclaim me, so I can argue the same thing. If you can provide me a reason why it's not reasonable, then we'll continue with the standard. Otherwise, we're going to change it. And I've been successful on that argument many times with that because oftentimes people are left. There's nothing you can say about why we shouldn't be able to mutually do that. You know, if you ask someone, you know, I have a question for you. Can you counterclaim against me if I sue you? If that answer is yes, then why can I do the same to you?
Exactly.
They usually don't have an answer.
Right.
And so it really becomes a question about reasonableness, and I don't care what standard, it's not reasonable.
Well, the answer is this is just the way it's done, and I'm the landlord will say I'm responsible to my client to do whatever the standard of negotiation is. If this is, you know, I'm not going to give in just because you ask for it. But we do have much more of an argument when we start saying that this is no longer the protocol.
Yeah.
Agreed. So add that to your list of another kind of pushback area that I think is ripe for negotiation. Paragraph 26 we talked about the waiver. Paragraph 26 is the inability to perform provision. It excuses the landlord from inability or delay in performing any of its lease obligations that's due to force majeure events, but it still requires the tenant to continue its obligations to pay rent throughout the lease term. Of course, this has to be read in conjunction with the constructive eviction provisions that may kind of overlay this and affect the tenant's continuing obligations to pay rent. In this provision, I would try to negotiate a reciprocal suspension of the tenant's obligations under the lease for inability or delay to perform as a result of a force majeure event. Again, there's no reason here that it should be lopsided. Bills and notices. Probably one of the most boring provisions, but again, one of the most consequential. It defines the parameters and the proper form for method and timing of giving notices pursuant to the lease. It's highly technical, and compliance with this provision becomes crucial in any event, in the event of any future litigation. This is where we'll talk about it a little bit next week, but this is where it's ripe for motions for dismissal, because I've very rarely seen a completely perfect set of papers from a landlord in the landlord-tenant court. There's always going to be some kind of defect. There's going to be some kind of T or I that's not dotted across in conjunction with the lease. The considerations here for the tenant are to identify the address and the method by which the tenant is reasonably certain that it's going to receive the notices in time from the landlord. Typically, I ask for regular and certified mail just to make sure that it absolutely gets there to the tenant or to like a trusted business manager who's there at the premises at all times or regularly during business hours. And I would include that to the extent there's any personal guarantor guaranteeing the obligations of the tenant under the lease, that the personal guarantor gets separate notice for any default in addition to the corporate tenant. I would avoid email and fax only notice as the sole methods of getting notice under the lease, because it's really easy to miss those. You could include them as with copy to. You could include it as an additional bills and notices service point, but try not to have it as this sole source. Commonly, drafting attorneys will include their law firms with a copy to recipients for all notices as a fallback. This keeps the law firm in the loop in the event that there's any defaults, but unless the amended lease will require copies of all notices to be sent to the law firm, in extension terms. Right. I don't know if we're necessarily going to be including that, because we are only representing these clients on a limited pre-litigation basis. I don't know that we necessarily want to list ourselves as a service recipient of all these bills and notices, because we could be getting 5 or 10 years down the line notices of, who is this? And we don't represent them anymore.
I say no.
I say no too. But so that makes it even more important that the client understand how they're going to be receiving these notices, and to make sure that they are checking their mailbox, or that they're that they have a PO box that they regularly check, and that they always are aware that they could be getting a very important notice in this in this method. I would include a provision that allows the tenant to modify or amend its notice address for the purposes of the lease in writing at any time, simply unilaterally by sending a notice to the landlord saying, hey, for all intents and purposes under the lease, this is the new address, or this is the new method that I want you to give me notice, and that takes effect immediately. Water charges. This piggybacks a lot on what we talked about with electricity. I'll go through it very quickly. It defines what water sewer charges are attributable to the landlord as additional rent. To the tenant as additional rent. The considerations again are that the tenant only pays for its own water usage. In the event that there is no submeter and that the landlord does not agree to install one, you should ensure that the tenant's portion of the building's water charges are reasonable, and consider water usage of the entire building's remaining tenants, occupants. If your client is works as an office, and they share a meter with the laundromat, you should make sure that you have a proper apportionment of water usage in that instance. Water bills are available through that website that I listed here. You need to register for a free account first, and they're semi-public. You technically need the water account number. Actually, I'm sorry, this is not quite correct. The BBL, the block and lot number is for the real estate taxes. That is technically purely public information. For the water bills, you do need a water account number, which you could probably get from the tenant in the event that there's any dispute. And again, ask the tenant whether they're going to need any kind of exceptional amount of water usage. If so, ensure that the premises is equipped to handle that kind of water usage, and whether the tenant is equipped for the charges that are going through. We'll skip over to paragraph 31. That's the security provision. Yeah.
About water meters, like we've definitely had tenants in the past who there wasn't a separate meter and they had a proportional payment thing, and then down the lease term life, they're like, there's no way I'm using that much water, or no way that I'm using that much electricity, and they think that they're like either being proportioned, improperly, or that, the landlord's just having to cover like all the common areas and stuff. Have you ever seen an ability of a tenant to call Con Ed or water and have them kind of come out and or on the phone give like what a reasonable usage is? Like, how does a tenant kind of figure out what either their sub-meter or the proportion should look like? Because even sub-meters can cover, like, let's say your lease premises and a hallway. Like, you don't know what the sub-meters actually feed into.
Yeah. I don't know the answer to that question. I don't know if there's any average usage for an office or average usage, other than kind of colloquial, anecdotal kind of evidence. I can say we're dealing with an issue right now with a tenant who is absolutely certain that her submeter and regular meter are winding improperly and mischarging her. And the best we can do is have an inspector come out and try to make sure that the meter is working properly. But in your instance where even the submeter is covering two different properties, you just have to make sure that it's as fair as possible and just do your diligence. I don't know, Kelsey, do you know if there's any utility inquiry that you can make about average usage of a particular type of business?
Well, I think you can get DP to come out to inspect the main meter, but the sub meter, I think you need to get a plumber.
Yeah.
I don't know about average usages. We've been having this big issue with one of the clients, but you can also, if we were just talking about yesterday, like you can file complaints against or whoever's reading the meter, which would be the landlord or they're contracting it out to someone else. Make complaints to the Public Service Commission and see if that helps. There's other implications about, filing complaints to the PSC, commissioner landlord.
I would also try to include in here in that provision, you do some investigation, have the tenant try to do some investigation, ask the landlord what's the meter, sub-meter setup. If you are sharing a meter and the tenant doesn't have the funds immediately to install a separate sub-meter for the tenant's own personal space, at least put a provision in there allowing the tenant to do that at his or her own personal expense. The landlord's probably not going to agree to that, to agree to do it at the landlord's own expense, but if you at least allow yourself the opportunity to do that as the tenant, that may alleviate some of the issues down the road where you find an issue, you think you're being overcharged.
And there's also a difference, for water, that you can have an actual bill or an estimated bill, because if they come out to get the meter reading and they don't get access, they'll just do an estimated bill. So maybe we'd also want to put in here that the tenant can request an actual reading and written evidence of the actual reading at any time. So that if you think you're getting overcharged, sometimes you might be getting overcharged because there's just been a backlog of estimated, and you can get a good adjustment. And I guess maybe if the actual results in a credit to landlord, that it's kind of passed back down proportionately to tenant.
Right. I would, absolutely. That's a good provision to include in there, as well as, like you said, all documentation supporting the landlord's charging of the utilities as additional rent before they're actually due. Security provision, paragraph 31. Security is a cash deposit that's held on by the landlord, paid by the tenant to the landlord to ensure the tenant's performance of monetary and non-monetary obligations under the lease. Theoretically, the landlord can dip into this security fund and use it throughout the lease term if the tenant defaults in any way throughout. The considerations here are the amount of the security is normally measured in a number of months of rent. So typically about 2 to 6 months, depending upon the size of the space and the perceived risk to the landlord of the then current base rent. So as the base rent in the goes up over the course of the lease term, the tenant is typically required to add in whatever additional security is required in order to equal the 2 to 6 months of security that's reserved under the lease. I would try to propose a burn down provision of the security under which the amount of security required to be held by the landlord is reduced after a certain period of time throughout the lease term, to the extent that the tenant has not defaulted under the lease, is in compliance with all of its obligations. That's not an uncommon provision. It's kind of rewarding a good tenant for being a good tenant after 2 or 3 years if you can reduce the security by, let's say, 1 month. And the way you can do that is having the tenant serve a notice that, hey, I'm in compliance with this term and I'm with this provision under the security paragraph. I'm also in full compliance with the entire lease. And the next month of rent will be set off by one of the months of the security. Basically asking the landlord to apply one of the security months to the following month of rent. I would also push for the landlord to hold cash security in an interest-bearing account with the interest paid to the tenant periodically. It's kind of an administrative burden that many landlords don't want to take on. They just want to try to hold it or commingle it with their own rent or with their own business funds. But to the extent that the security reaches kind of higher amounts, there's potential for some interest there that it is the tenant's money it should be reaping the benefits of. And then finally, I'd like to kind of put on your radar a letter of credit. Normally, it's something that is reserved for larger or more sophisticated tenants, but I think there's a potential for smaller businesses to be able to use a letter of credit in lieu of cash security. A letter of credit is a bank's guarantee of payment to a third party, here the landlord, and typically requires some form of collateral. So let's say the landlord requires the tenant to provide $5,000 of cash security. The tenant can go to a bank and say, hey, I have this deep fryer that I use for my restaurant. I'm going to give it to you as collateral, and you give me a letter of credit saying that you're holding this collateral and that you will, upon demand, pay $5,000 or up to $5,000 over to the landlord in the event A, B, and C occurs. And so in many instances, that letter of credit will be sufficient for a landlord under the security provision that allows the tenant to use a lot of cash, not to have another cash outlay right in the beginning of the lease term, and to have more cash on hand available for investing into the business right when it's starting out in its lease. So like I said, for the tenant, it avoids a significant cash outlay right at the initial term. It can use cash to reinvest in its business and moving its business instead. However, the tenant does need to have some form of valuable collateral that can be encumbered by the bank. For the landlord, having a letter of credit avoids a clawback of cash security into the tenant's bankruptcy estate, because a letter of credit is not a part of the tenant's bankruptcy estate. So in negotiation, if your client has the ability and wherewithal to be able to get a letter of credit instead to comply with its security obligations, you can try to get the landlord to agree by saying, hey, in the event that there is a bankruptcy, whether it's voluntary or involuntary, you're still going to have this letter of credit, and you can still theoretically draw upon it because it doesn't become a part of the tenant's bankruptcy estate. I don't know necessarily how that's going to come up. I don't know if you necessarily want to be talking about bankruptcy in the negotiation phase, but that's something to know. To the extent you do use a letter of credit instead of a cash security, I would definitely require that the landlord provide any notice to the tenant that it's giving to the bank when it's trying to draw upon that letter of credit, just so that the tenant knows that it's that's going on, because it does have some collateral in the game here. Paragraph 35 are the rules and regulations. These are the house rules. These are really a boilerplate, and a lot of them are going to be either amended or talked about in more detail in the rider. But what I want to draw your attention to here are the signs provision. Our tenants are really going to be wanting to put up signs to attract businesses, and you want to modify the provision in the form lease, or have a provision in the rider that allows the tenant to install the signage that it needs for its business reasonably without the landlord's prior consent. Or if you do need the landlord's prior consent, of course, make sure that it's not unreasonably withheld, delayed, or conditioned. And I would also include a provision to ensure that there's no additions or amendments to the rules and regulations, and they won't take effect until after the landlord notifies the tenant of them in writing. Quickly, I'm just about wrapping up here because I know we're running late. We're going to talk about personal guarantees and real estate taxes. Personal guarantee is an agreement by a creditworthy individual to take on a personal liability for all or certain specified obligations of the tenant under the lease. They can be monetary obligations, they can be non-monetary obligations. This is in the event where typically a corporate entity is the named tenant on the lease. The landlord wants to make sure that there is an actual physical human being with money in their pockets to be able to fall back on in case the corporate entity dissolves or disappears. The adverse considerations here for the tenant are the form lease guarantee that you have here. It's on, if you blink, you might miss it. It's all the way up here on the very last page. There's this tiny little paragraph up here, right under the guarantee, and it is a hell or high water guarantee. It's a form guarantee that's an unlimited personal guarantee for every single obligation of the tenant under the lease, both monetary and non-monetary. It gives the landlord bankruptcy-proof security. So, of course, if the corporate tenant files for bankruptcy, the personal guarantor is still on the hook. And there's no requirement for the landlord to actually go to the tenant as a first resort for any default. Technically, if this is the only guarantee that's in effect, and there's a lease default, the landlord can go directly to the personal guarantor first to try to get that resolved. This guarantee, as written, is not discharged upon expiration or termination of the lease or after vacator of the tenant from the premises. It survives, and the personal guarantor stays liable. Remember that we talked about the landlord's lack of a duty to mitigate its damages. So if there's 4 or 5 years left on the lease term when the tenant vacates or is evicted, not only will the corporate tenant be responsible for all of the remaining rent for the lease term, but the personal guarantor will as well. That's something to keep in mind. Typically, you don't see tenants just signing this form guarantee anymore because it's so onerous. So a couple of decades ago, the landlords and tenants actually came to a compromise called the good guy guarantee. And this is a limited guarantee that may be a little bit less harsh than the traditional guarantee here in the form lease. Its purpose is to incentivize a defaulting or a holdover tenant to return possession of the premises to the landlord. And the key benefits here are that there's a certain period during which the personal guarantor's obligations are in effect, and that period of time is limited. Normally, it's from the date of the default until the date that the tenant returns possession of the premises to the landlord. So the personal guarantor has the ability to end the personal liability under the guarantee by persuading the tenant, or if he or she is the tenant, to just return the premises and give the keys back to the landlord. At that point, the personal guarantor's obligations are over under the good guy guarantee, and potentially the tenant corporation can dissolve or cease to exist if there are any other obligations remaining out there. A key benefit, we talked about that, some negotiation considerations for the good guy guarantee. Try to limit the scope of the non-monetary obligations, for example, maintaining insurance, delivering the property in broom clean condition. The non-monetary obligations should be the tenant's responsibility. Try to limit also the good guy guarantor's monetary obligations. That's going to be a little bit difficult because that's the exact purpose of the good guy guarantor, but make sure there's nothing ridiculous out there, no treble damages or anything like that. Make sure that the good guy guarantor isn't obligated for anything more than the prime tenant, the named tenant, is obligated to do. And ensure that the good guy guarantor is entitled to all the notices that the tenant gets under the lease. Ensure that there are no onerous obligations in order to end the good guy guarantee period, that the good guy guarantor can simply deliver the space to the landlord in broom clean condition, sufficient to close the period of personal guarantee. And then finally, ensure that the good guy guarantee ends and terminates upon sublet or assignment. Connecting back to that assignment provision, even if you don't get a replacement guarantor, try to see if you can still get a provision that ends or terminates upon sublet or assignment, because somebody else has stepped into the shoes of the tenant in the premises. Finally, real estate taxes. Real estate taxes don't appear in the form lease specifically, but you will see them in the rider. And it's important to know what your client's obligations are for paying the real estate taxes, because they can be pretty hefty. The provision is going to apportion responsibility for paying all or a portion of the real estate taxes and the related taxes for the premises, like bid taxes and whatever else is included in the real estate tax bill. The rationale for the landlord for including real estate taxes as additional rent is that the tenant is the party that's actually using the premises and benefiting from the government's expenditure of property taxes, and so the tenant should be the one that's responsible for a portion, at least a portion of the building's property taxes. As an alternative, the landlord will be incentivized to roll real estate taxes into tax payments into increased base rent in the event that they weren't actually, sorry, let me try that again. If real estate taxes were not a part of the rider, the landlord would still be incentivized to increase the base rent to cover its own expenses for real estate taxes. So this is potentially unavoidable, and you just want to make sure that your client isn't paying more than its fair share. The forms of the tenant's obligations are here on the next slide. Your tenant could be required to pay all of the assessed taxes due or a portion of the assessed taxes due. This is where the landlord simply forwards the bill and says that this entire real estate tax bill or an X percentage of it is due. It's a larger burden on the tenant. It's more common in large net leases, triple net leases, where the tenant actually takes on the entire real estate tax obligation. More typically, what you're going to see, or what you should be seeing, is the tenant's obligation to pay tax escalations. So in this instance, the lease rider will set a base year, and the base year will be, it's usually denoted by 2 years. So let's say base year 1516 is the tax year that ends in June 30th, 2016, since the fiscal year of the city runs June 30th to June 30th. And so when you see fiscal year base year 1516, you know that you're going to look up the real estate taxes that were due for the premises from July 1, 2015 through June 30, 2016, and count that as your base year. Whatever escalations there are in subsequent years throughout the lease term over that, the tenant will be charged all or a portion of that pursuant to the real estate tax provision of the rider. So that should be the kind of provision that you're going to see, the escalations. Which one?
You just noted that the tax escalations were common for a small tenant. Why is that?
It's less of a burden. Why is it more common? It's paying all of the real estate taxes is something that's really burdensome for the tenant, and the landlords realize that unless a tenant is a really large net tenant or has kind of a really long-term lease, they're not going to be willing to pay all of the real estate taxes
How about a square footage
for the premises.
proportion?
Sorry?
How about square footage proportion of the
That could
total?
be a way of determining what the tenant's share is. So in addition to what the method of assessing whether it's assessed total assessed taxes or tax escalations, there's also going to be a proportionate share. It's a definition of tenant's proportionate share of those taxes due or of those tax escalations, and it could be based upon a square footage as compared to the entire building. This is you just see for smaller tenants, you just see tax escalations, because otherwise the tax burden would just be way too high for tenants.
There is a program, I know that I looked into it for one of our projects, so I'll find it, that there is some commercial businesses which can get real estate tax exemptions if they're providing commercial activity in kind of a blighted area. We were looking into it for a supermarket and a food desert. And so if a tenant is only on hook for like a proportion of the escalated property tax, probably not worth it. But if we have a lease with a tenant who they're really paying like a proportionate share of the whole thing, they can get an exemption of their proportionate share under the lease. So in some instances, it might actually be worth it, and the client could, unfortunately not for our services, but could apply for it on their own and see if they can get it.
Absolutely.
So
Yeah.
I'll send a link out.
That would be great.
Just as an FYI. I didn't realize that. I was thinking you guys would be nonprofit using it for your nonprofit purposes, but there is actually in some instances real estate exemption for commercial activity.
Excellent. I didn't know about that. The negotiations considerations that you're going to make in the real estate tax provision. First, I always pull and review the real estate tax bills, especially for the base year, just to get a sense of what the burden is for the premises and what it's going to be proportionally for the tenant. I would ensure also that they don't include any exemptions or abatements that are going to be phased out over the course of the lease term. If you see anything funny going on in the base year, if it's like exceptionally or artificially low and it's going to increase exponentially over the lease term, that's going to really increase the tenant's obligations, and it may be untenable. Ensure the definition of taxes is not overbroad, and ensure what exactly counts as a tax that's due under the real estate tax provision. Sometimes it's not apparently clear that it's just real estate taxes that are found within the four corners of the real estate tax bill. And try to seek exclusion of certain taxes. A lot of these provisions are blank or form provisions that are just used over and over again in forms, and they may try to include transfer taxes, income taxes, estate or mortgage taxes. Those should not be a responsibility of the tenant. Try to ensure what the billing procedure is that the landlord is going to use in order to bill the tenant for these additional rents. I've seen monthly estimates where the landlord just takes the prior 6 months or the prior year of tax bills and then just estimates what the following 6 month or 12-month projections are, and then bills the tenant together with the regular monthly invoices, 1/12 of that or 1/6 of that. And then at the end of the year, when the actual real estate tax bill comes out, then they'll actually true up or down whatever balance there is. You can also do an annual lump sum where the landlord actually waits until the end of the year and then it actually bills the tenant for whatever taxes or tax escalations are due. That's a higher burden. The tenant doesn't have to pay throughout the year, but the tenant should be aware that there may be and that there will be significant expense at least once a year on that. Definitely ensure that there's proper notice of taxes due from the landlord, that they actually provide you with copies of whatever supporting documentation they're using to calculate their number. It becomes very tricky and complicated, especially when there's a proportionate share over a certain base year. So there's some math that needs to be done here, and you should have the landlord show their math when they're billing you. You seek to limit the landlord's ability to serve real estate tax bills after the expiration of the lease. The landlord's going to want to say that, even if I delay 6 months or a year after you're out of the premises, you're still on the hook for it. You still use the premises and it's still due. But I would try to push back a little bit there as well. It's just not fair if they finally wake up a little bit later. And I would include the right but not the obligation of the tenant to contest the real estate tax assessment and to recoup any overpayment that it's made to the landlord if it's successful, as well as an agreement by the landlord to sign any paperwork that's necessary, because it's the owner, in order to effectuate the tenant's tax contest. There's actually a service, I'm not sure whether they operate in New York City, but it's on my list of things to find out, that they'll go and, on contingency, prosecute this whole tax contest for you if you think that you were overassessed. They'll go and they'll prosecute the tax contest for you, and then if you win, they take a portion of whatever overpayment that there was.
I've seen private firms do that.
Yeah.
In New York City. I don't know if there's another service, but there's definitely private attorneys who, that's what they just churn every day. It's like real estate assessment contest.
So that may be something to put on the radar of our clients. And here's just an example of what a tax bill looks like in case you haven't actually seen one. This is one that is assessing charges that are due on July 1st, 2017. So through the first half of fiscal year 2016-17, or second half of 2016-17, it's $90,229.16. That's the finance property tax assessment. And then right under that, you'll actually see the estimated assessment for the following half of the year. That may be where the landlord takes and tries to do some estimated monthly payments. They'll take $90,000 divided by 6 times whatever the tenant's proportional rate is, and they may go ahead and try to bill you on a monthly basis. It's about it. You may see some bid taxes here as well. They're included. If there are any abatements, they'll show up here as well. Tax abatements, they should be known on your radar. That's about it. So that brings me to the end. I was going to go ahead and talk about some, how we're gonna handle our ongoing group discussion, our staff meetings monthly, kind of developing the model provisions. We've talked a little bit about this, so we don't necessarily need to go into this now. It's 12:18, so if you guys have questions.
Should we say them or can we ask?
What do you guys
Should we
wanna
say
do?
the quality of people's abilities taping this evening? I don't think we have much time.
How long is the litigation session on Monday? Because I'm wondering if we should cover questions on Monday.
So 9:30 to noon, it's
And you guys
scheduled
think we're
for.
gonna take that full time?
We could take even longer.
Or I could do my